Good evening, YouTubers. I hope you're having a wonderful day. It's Tuesday, 8 p.m., our regularly scheduled live stream. So glad to be back. I missed 1 week, and it seems to me like I've been away for a very, very long time, so I'm so thrilled to be back. As you know, I've had a pretty rough week and a half or so, but getting back to work is often an absolute blessing. It allows you to focus on what's in front of you and sometimes forget some of the problems that are going on in real life. So I really do appreciate being able to come in front of you. Do me a favor as you get in, let me know if the audio is okay, if the video is okay. I want to make sure that before we get any further that everything is working well. I don't want to be glitches later on. Let me just see. Perfect. As always, this is a live stream, right? It's not a recorded video, which means it's about a conversation between you and I. So please, when you come in, you have a question about our current fight for free speech, or really anything else, any legal news that you came across, any legal question that comes up in your life, please put it in the question. I will get to it. Just remember, as you can see down here, put an @youtuberlaw. If you don't put an @youtuberlaw in front of your comment, it's going to be skipped. Never going to know that you want to send it to me. I'm going to assume from my end that this is actually something you're discussing with somebody else. So people complain sometimes when I don't read out their comments, but that's all you need to do. Just put an @youtuberlaw. What happens is on my end, I see a little orange box. You don't see it, but I do. So when you put an orange box, I see you put an @youtuberlaw. I see an orange box and it tells me to read it. So I'm going to go through everything. I'm going to read one after the next. So just be patient because it is sequential and it can take time, but I'm going to do my best. The only time I don't get to any question is if basically my throat dries up and I cannot speak anymore. But lately I've been better and better at it. Plus, in the past, because of the time it takes to answer a question, some of the original questions were erased just automatically by YouTube. That's not going to be an issue anymore. 5x5. All aspects 5x5. Meme of destruction 5x5. It's a square. Why is it a 5x5? Everything looks good. I have no idea what that means then. Because if I messed up on the aspect ratio, I apologize because I have no idea what I messed up on. I wouldn't even know where to start looking right now. So we'll see what's going on here. But yeah, but none of the comments are going to be lost because my wife is actually copying all your comments and putting into a Google Doc. So I'm going to see it all in front of me. So don't worry, I'll get to it. If you want to skip the line, you have no patience, or you're here for a short time and you want to make sure that I respond quickly, that's where Super Chats is. Obviously, I appreciate the contribution, but basically it's kind of a Disney Fast Pass or a Universal Fast Pass. Just lets you skip the line, but you don't have to do so. Just put your question in and I will get back to you. As always, what's going to happen here is we're going to have a live stream. When it ends, it's actually going to be archived. I mean, it's not going to be available right away on this channel. What I'm going to do is actually upload this live stream to the secondary channel called Legal Dissent. If you haven't subscribed to it, go ahead, subscribe to Legal Dissent. There's a link down below. I'm going to upload basically a summary, a small condensation, a small summary of the video back to this channel tomorrow or the next day. So before we start, I just wanted to thank you. As many of you know, my family had a very rough week and a half with the passing of my mother-in-law. Very, very unexpected, an amazing woman, lots of energy. She's the kind of person who would show up on your doorstep at 10 o'clock at night with tons of energy. Let's do something. Let's go shopping. Let's get something done. I could never keep up with her, and she meant a great deal to me. And so it was devastating to the family when she just suddenly died. And people always say how terrible things are on the internet, how it's toxic and people take every advantage to be absolutely mean. And unfortunately, sometimes we are our worst self when we are behind internet walls and nobody knows who we are. I'd like to tell you that my experience was just the opposite. each and every one of you has been just amazing, compassionate, loving, only offering best wishes to me and my family. And from the bottom of my heart, I wanted to thank you, because all the comments, whether or not it was on Twitter or on YouTube, have just been mind-blowing. It was so compassionate. I read each and every one of them. I didn't respond. I read each and every one of them. My wife did. It meant the world to us. So thank you so much. I really, really appreciate it. Now I want to get into a bit of an update on what's been going on in the case. Obviously, I was away for about a week, so I wasn't really as deeply involved in it, but the team kept going. And if you not on the inside, it's hard for you to realize how hardworking everybody is. About a week ago, there were about 80 volunteers. There's some core groups, some small core groups that are working on specific product, and there is also a large contingency that we are trying to deploy on different areas where we can use more and more people on. So like we said before, there are about 5 groups. The legal group is moving forward with the drafting of the complaint. The business analysis group it basically acts in support of the complaint, because as we spoke, antitrust is a combination of economics and law. So we need a lot of sort of business analysis to actually support the complaint. We got a web group which has been working hard on developing a website, just a very nice interface that gives people a lot of information, and then also will serve as the base from which people can then deploy different tools. Speaking of tool, is the tech team, which is a broader group. A lot of great professionals have done some really kick-ass work building the tools and the infrastructure that not only the rest of the team are going to be using, but also looking into the future, into what this might mean and what kind of infrastructure we need going forward, even beyond this particular project that's in front of us. So I want to be able to discuss with you some of the needs in terms of volunteers that we have, because even though we have a very large group, there are certain skill set that we can use more of. So I just want to share that a little bit with you. So in the business analysis group, we need more and more people who are interested in searching out information. We need people that are searching out information, are able to actually very quickly ascertain what's in front of them and bring it back so that the legal team can actually utilize it. So if people are interested in business analysis, a lot of searches online. Contact us. Just go to youtuberlaw.com. And through that, join the Discord, and we'll try to place you in the right group. Second is the web team. Our website is very advanced, but over time, it's clear that we will need some sort of a webmaster. Somebody who's really can manage the content, manage some user interface, really design, understand how people are using it, and can on an ongoing basis kind of manage the actual site beyond the programming. We have lots of very talented programmers, a lot of people that are great designers, but we need kind of a webmaster. So if somebody has some expertise in it, much appreciated. And then there is our promo group, which is a group that tasked with a very large role of actually raising the awareness of the project. We always spoke about how if we are going to submit this complaint, it's not enough that we create the single best complaint anybody has ever seen. We need to raise the attention span on this particular project, because the FTC is an organization that has to choose. It cannot take on every single case, and it makes decisions about which case it takes on. Sometimes it's because it's recommended by somebody in Congress, sometimes because it's recommended by the president. They don't really have to answer to them, but it is very meaningful. But a lot of times it's based on what their assessment of what is an important case, what kind of a case may have a negative impact on the economy, because ultimately they are charged with actually making sure that the market is staying competitive. So social awareness and raising the awareness and engaging people when it comes to this project is very, very important. And the promo group is what charged with it. And we need more people. I apologize, more people in that group. Specifically, we need people at the management level that are familiar with actually building, creating, designing, and running actually a promo project, knowing how to actually design it and run it and manage it, basically. So people with expertise in advertising or in PR If you could reach out to us, we appreciate it. Also, people that are influencers, people that have reach. Basically, once we are in a position to implement some of the project that, some of the promo project that we have in mind, we need more and more influencers that can actually help us spread the word and reach different non-for-profit, different user groups, potentially senators and congressmen. So that's another task that another set of skills that we are in need of. And last, and we spoke about it before, we are still in desperate need of a good hashtag. It's just something that has been very difficult, maybe just a lack of creativity on my side, that we need some serious hashtag. So I'm going to turn to you. Anybody that has any idea, you go to Twitter, just do @youtuberlaw and put a hashtag. Put one hashtag, put 10 hashtags. Anything that you think would be good, useful, instructive, or just funny, something that you think is catchy, we'd like to deploy it. So give us ideas. Just send anything that you have to @youtuberlaw. You don't really have to put anything inside. Just put a bunch of hashtags. Send it our way. We'd love to see if we can incorporate it into it. Obviously, we'll give you all the credit in the world if we choose your hashtag. And I think that's about it. What we're going to do right now is I'm going to jump in, ask any question you have. Obviously, you can ask any question about this particular project. There's a lot that's going on here. And yeah, I have to be sometimes cagey about everything that I'm revealing because there's some important things that are going on behind the scene, and I cannot reveal everything of what we're actually doing because it is a legal action, and we want to make sure that we have certain advantages that would be weakened if I completely reveal everything. But absolutely ask me anything about the legal issue. Ask me about any other issue. Obviously, I uploaded another video this earlier today. You can ask me about that, but you can ask me any question, any legal question that comes up in your own personal life or online. Let's go. S. Jar Jar Binks, thank you so much for the super chat. The YouTube Trump Twitter blocks. Why have not Twitter not sued the court over not using eminent domain, but instead giving an order? Do they not have to use the cannot Twitter tell them section 230 go away? That's interesting, right? So I did a video earlier today that I uploaded about the fact that there was this bad decision, we spoke about it a bunch of times, in New York, where individuals sued Donald Trump for having blocked him off of his Twitter. They won at the district court level. The administration is now appealing it. I believe there's going to be oral argument sometime in March. I believe that's what I saw. But in the meantime, a court, another federal court in Missouri, is using that as the basis. And my argument is that that makes no legal sense at all, because the way they got to it is the judge in New York said basically that once a tweet is sent, the tweet itself is not subject to free speech, but it creates this kind of a bubble, a virtual space beneath it, which is effectively a public forum in which people cannot be blocked. And that's how he justified the idea that Donald Trump cannot block anybody off of his Twitter feed. Same thing happened in Missouri, where a congresswoman, a state rep, I believe, actually not a congresswoman, a state rep blocked individuals off of her Twitter feed, and this case is moving forward. So the question is, why would Twitter allow something like that? Well, first of all, you have to understand this is just district court level. This is the first level of the federal court. I'm certain that if this somehow fails, or either the administration drops it, which I can't see happen, or it keeps failing in court, that Twitter would actually interject itself. They're watching it very, very carefully, because for them, that decision is disastrous, because there's certain implication. Basically, if you say that everything, the court acknowledges, everything is private, right? The company is private, the product is private, everything is run on private servers, the code is private, and yet an individual who just receives a license, he sends out a single tweet because of his position and because of what he might say as part of his position, that creates a virtual space beneath the tweet that is otherwise public forum. Well, I mean, my argument is it makes no sense because it never happens in real life. If a government wants to take over your personal property, private property, they have to initiate eminent domain proceeding, effectively paying you, right? I believe that's the Fifth Amendment to the U.S. Constitution that says that you cannot take private property without just compensation. You cannot do that. It makes absolutely no sense for a judge to say that a single tweet can actually create this kind of a virtual space where otherwise it is private but turning it into public. The logic doesn't work. And if that is actually ends up standing, my argument was that Twitter, Facebook, YouTube will not be permitted to actually ban anybody. That's how absurd the idea is, because if there is virtual pockets of public square within their platform, then they can never ban anybody, because private companies who manage public forums are restricted just like the government. So they would not be permitted to ban somebody off of Twitter because he needs to be in a position to respond to any public official that's actually sending a message off of Twitter. So yes, why isn't Twitter responding? Well, because they're waiting. First of all, they're waiting to see what happens on appeal, want to see who wins out. It's really uncertain. They might at some point actually file an amicus brief, merely to want something in support of it. They would be in opposition to it because it goes against everything that every one of these platforms want. They don't want there to be a public platform, to be a public forum. So they're watching. Section 230 probably would not be applicable here, because Section 230 means that Twitter are not going to be liable for the tweet of the individual who is using it. So I guess I can see what you're saying, because it's effectively liable, because if you allow a user like a president or really anybody else to submit any sort of tweet or an article or a video to your system, and that actually effectively takes away space within your server and creates a public forum, doesn't that effectively make Twitter then liable? Doesn't that go against Section 230? So I see your point. It's a creative approach to it, and I can appreciate what you're doing. I'm not sure if anybody thought of it. I definitely didn't think about it before, so I commend you for coming up with that idea. But I think they're just watching. I think that they are not going to step in unless they see that as a risk. They're risking further loss. I personally think that this on appeal is going to get thrown out because it makes absolutely no sense. Great question, by the way. Jar Jar Binks. Excellent. Thank you so much for the super chat again. Was then going to add at that point that would now basically set a precedent to make 230 useless. Perfect. It's exactly it. I mean, again, you were thinking ahead. I didn't really see the impact on Section 230, but you're right. It would make Section 230 completely useless when it comes to public officials. So it would only be useful when it comes to private individual, but public official through the virtue of a single message, a single article, a single video would then be usurping property and turning private into public, which makes absolutely no sense. Now, again, I believe that none of these platforms should ever be banning anybody, censoring anybody absent some awful language. I believe that free speech should reign and should be encouraged. Nonetheless, this is not the solution, because there is no real logic behind that idea that a single tweet can actually turn what is otherwise private into public. And to me, it always sounded like the judge, the original one in New York, I think this judge might have been a little lazy and he just adopted whatever the guy in New York said. But in New York, basically had an idea how things should be, and then kind of build up the argument because he wanted to reach that conclusion. That's how it sounds to me. Because to be honest, if you were to ask me, should a president be allowed to block somebody or should a state rep? It sounds to me like they shouldn't. But I cannot come up with a legal argument to justify it. So just because it feels like an official should not be allowed to do that, that is not sufficient to create a legal argument. You really have to come up with something useful. And what the judgment in New York and now the one in Missouri is relying on, to me, makes absolutely no sense. Elhi Nuggets. Elhi, not the Nuggets. Okay. Is this, or is there a way to make our comment or question legally binding to be read? There is. I don't know if this is a joke or not, but it's an interesting question. because the answer is no. Because the closest you can get to it is through a super chat. But the way YouTube wrote it, and they did it to protect their own butts, they are not saying that you are giving money to the content creator. So when you do actually a super chat, there's no direct relationship between you and I. What it is that you are effectively buying color and font from YouTube, which basically highlights your message and keeps it on the screen longer than otherwise, depending on how much money. So the answer is no. Even through a super chat, there is no obligation, because the way YouTube actually set it up, you get it the minute you pay, because then they highlight your question. So the answer is no. Sorry, but you put the question down, I'll do my best to answer it. Mackhill Gore 06. Check above Kazia Thornhill mentioned Proud Boys back account being closed. I'm familiar with it. I just don't have enough of a background on the entire story. So I'm just not prepared to answer, because I don't want to say something that based on just half truth and things that I've heard. I haven't had a chance to really look into it, but it's definitely something. I'm going to write it down right now, and I'm going to take a look, and maybe we can do either a recorded video or talk about it next week. Dreamwalker, is there such a thing as hate speech, and what is it? Is there such a thing? There is such a thing as hate speech in colloquial language. You know, and as such, there is no definition except whatever you see ultimately in Webster Dictionary or in Wikipedia or whatever is being adopted. If you're asking, is there a hate speech in law? The answer is no. In fact, in the United States, law is antithetical to the entire concept of hate speech, because there is an assumption when you call something hate speech that it's impermissible. And the law does not make distinctions between speech absent illegality. So absent certain things that would make it illegal, like defamation, saying certain things that are untruth as to facts which actually hurt somebody, that's basically defamation. Sometimes copyright infringement or trademark infringement, depending how it's used, that might be an issue. There are certain language that can be used. Incitement, basically saying go attack an individual right now, inciting people. So with beyond certain basic elements in speech, and it's very, very restricted in the United States, speech is legal. Speech that represents love and speech that represents hate, is speech that encourages and lifts us up, and speech that puts us down and make us feel like crap. It's all equal under the law. So under the law, there's no such thing as hate speech. It is something that society developed to target speech that it does not approve of, or that somehow indicates or tries to put down individual or hurt them through the element of speech. It's a dangerous thing here when you apply colloquial language to a platform that is basically a source of speech, because then there are no true legal standards to apply here. The law is not going to help you. You can't take a look at some case law and says, that's what hate speech is, that's what I'm going to apply here. The law does not help you, because the law does not recognize it, because it's completely legal to express hatred. However much you may find it distasteful, that's part of the nature of free speech, that it's up to us to make decisions about what to say and how to say it. It's not up to the law. But unfortunately, in our today's world, the assumption is that private companies controlling the forms in which we speak should be allowed to control our speech. There's stuff we can do to fight it. That's what we're trying to do as part of our case. If you can support us, join us. S. Jar Jar Binks, thank you again for the super chat. So why then does YouTube give you some of the money that seems telling and possibly incriminating? Okay, so there is how YouTube organized it, and sometimes how YouTube kind of markets it and what it seems. When you give money, you're thinking of it as giving it to me, right? You're paying for a question, you're paying for a response, or whatever you want in response to it. YouTube designed it otherwise, and they say what we are giving the content creator is a share of the advertising revenues. They are selling them a product, and because it is promoted on a live stream belonging to or generated by a content creator, they see that as an advertising share, which is no different than any other advertising on YouTube. Now, is that necessarily valid? We had that argument before to say that it's not really valid in certain instances, because YouTube is saying that in order to cover their butts, because they want to be in a position to say that you are never eligible to receive your money back if the content creator doesn't get it. The way they design it allows them to sell you the product, which is the highlight. But if they figure that for some reason the content creator should not, in their opinion, receive the money, they can actually block it from going beyond that, so they don't have to remit it to or share it with the content creator. That's the legal idea behind why it was designed that way. And they've set it up so that all super chats are paid through Google Ad, which is the same way, right? No, AdSense, sorry, Google AdSense, which is the same way a content creator gets paid for any sort of advertisement. So they set it up specifically. I think there's room to challenge that idea, because it doesn't work well logically, because the way the rules are, the content creator actually earns it the minute YouTube receives it. So it's actually never permitted not to forward the money. So their argument that it's a product that's being sold by YouTube, that they earn it at that point, and it's not really earned by the content creator, doesn't really hold water. But who's going to challenge it at this point? You'd have to find some attorney who would do like a class action lawsuit. Not an appealing prospect, really. Jar Jar Binks, have you tried large quantities of alcohol? That's why hasn't Twitter sued the court? That's why hasn't Twitter sued the court for the Trump tweets blocking, since they haven't gone through an eminent domain process? Have I tried large quantities of alcohol? There's been the days. I think I responded to that one, yes, because that had a super chat attached to it, so I responded that already. Kazia Thornhill, have you heard about Chase canceling one of the leaders of the Proud Boy account, and he's having an issue with his merchant's account? He runs a merch store for creators. I heard about it. At the end of the day, people, again, I'm not speaking specifically about the Proud Boy, but I'm speaking about banking and credit facilities, and there's a prohibition in law against discrimination when it comes to that, but it's limited to very, very specific things like race, gender, age, national origin, things of that nature. I believe also whether or not you're receiving subsidies from the government. Nobody can discriminate you. But beyond that, there's no general prohibition, no general right to access banks or credit card. Just doesn't exist right now, which allows them to make a lot of decisions about where they provide certain facilities. And that's why they also can decide, you know, if they think that your business might be too unsavory for them or may expose them to certain risk, you know, whether or not they're concerned about terrorism or money laundering or anything else like that. The problem is it has grabbed a lot of businesses, absolute legitimate businesses, that for one reason or another is being marked, and facilities have been withdrawn from those businesses. There actually has been a case about this kind of issue in the past when it comes to payday loans. They've lost a lot of their payment facilities in the past for no real reason, except that we know now that it was pushed forward by Visa, MasterCard. But I would have to check the particulars of Proud Boy. I just know the storyline. I don't know the specifics behind it or what could have brought it on. So I have it written down. I'll check on it. Chris Bethune, in radio, 5.5 is the most optimal signal you can get. That shows you how much I know here. I thought that somehow I changed the actual measurement of the screen to a 5x5, almost like an Instagram kind of look. So thank you so much. Now I feel like an idiot. Polchani audio sounds good. Excellent. The meme of destruction. Do you think the precedent set by President Trump Twitter case may lead to certain folks like Lior Leser who were banned after criticizing politicians having their ban lifted? That's fascinating. See, that's the whole point here. That to me, a judge who wanted to rule a certain way then was forced to basically create logic that otherwise doesn't make sense. But if you follow that to its logical extension, that's exactly what can happen. Because, and if more and more courts adopt it, and if it doesn't get reversed on appeal, then that's the implication that you will not be able to ban anybody, including Lior Leser or anybody else, because they are permitted to be in a public forum. And as long as they are any public official on Twitter, and it doesn't make a difference if it's some local commissioner in a little village or the president of the United States, as long as there is even a single public official that is tweeting anything that might be related to their job, even if it's a private account, if they're tweeting anything that's related to their job, under the current logic means that they've created this little bubble, a virtual space of a public forum. And a private company that manages that public forum is not permitted to restrict to you. You have to think about it this way. We have parks, and some parks are not managed directly by the municipalities. They are managed by private companies. We know that from golf courses. There's a lot of instances where public land is not actually managed by the local municipalities or by the government, but rather by management companies. But the status of the property is basically lies with the fact that it is a public forum. If it invites the public to it, it's nothing to do with whether or not the management is done by a private company. So the logic that you mentioned, that's where it goes. So if people want to do that, if people actually want to adopt this kind of a logic and argue that the case is correct, and President Trump or now this state rep are not permitted to block, my argument is that Twitter, Facebook, YouTube are required to allow everybody that they removed based on the content of their speech, they are required to bring them back. Clan Sith, my condolences to you and your family. Thank you so much. I really appreciate it. M2HMGHB. Woo. I'm sorry for your and your family's loss. Thank you so much. Really appreciate it. John Taylor, sorry for your loss. Please give your wife my best. No need to respond or to read out loud. Too late. Thank you so much. Project Nemesis. What is your current analysis of the legal issues surrounding Julian Assange? I really never did an analysis of it because, well, because it's just never been something that anybody has ever asked. You're literally the first person to have ever asked a question about him, so I never really looked into it. To me, the question is, what exactly is the crime? Because that has never been really explained to me. You can argue that what he did was injurious to the United States, and you know, I mean, people can argue both ways that there was injury or not. The question is ultimately, what is really the crime? Did he actually break into any protected facility? Was he providing access that he otherwise broke? Meaning he was provided some secure access and he took out information that he was not permitted to do? No, I mean, the argument is, which is kind of like what you would say from a newspaper, that he received information that the person who leaked it did so without proper authorization. The problem is that that's normally not what you prosecute, because you don't usually prosecute the newspapers for having received that information, because that's what whistleblowers are all about. They are basically giving information that otherwise they're not permitted to. They're often under contract not to do so. Obviously, the argument here will be that this is different because him or any journalist is receiving information that they know was received, that was acquired illegally or in one way without permission, and in fact can cause real danger, can cause harm, and they should have he should have treated in a certain way. To me, it's not clear what exactly the law is. To me, it seems that the government very much upset, and I'm not blaming them for being upset, the fact that information was leaked, need somebody to point their fingers at. And right now he's the poster boy, rather than take a look and why the hell why they're not able to manage their own internal secrets. They want to collect information from us all the time. There are proposals right now to do national privacy laws where somehow that's what Apple actually, Tim Cook suggested, that the government should be the repository of all data, and they should control how data is being managed. What a ridiculous thing. The government cannot control its own data. Are we going to trust the government with our data and allow them to decide who receives our information or not? So it might be time to take a look at that issue. Let me actually write it down, because that's actually kind of an interesting topic I haven't looked at in a long time. I'll take a look and I'll try to give you a fuller response on that. Becky S., thank you so much for the super chat. There's a congressional race in North Carolina that hasn't been called yet 3 months later. Do those voters have any legal recourse? It's usually the legal recourse is usually tied to whether or not the rules were actually followed in the process, because you could actually technically file lawsuits against the private officials based on how they follow the letter of the law when they do that. For instance, in Florida, we know how many problems there have been with elections in Florida. The saving grace, you want to call it, is that there are hard deadlines beyond which decision is made. Even if not all the votes are counted, even if there is a question about validity of some votes, whatever the result is of a certain date, it's actually determined. So you don't run into those kind of problems. But if the state allows that, because how voting takes place is not up to the federal government, it's up to the state government and the municipalities. Often, it's in Florida, it's really a lot of times up to the local municipalities to manage it. If they're not breaking the law in the process of not actually resolving it, there is no real recourse. Sorry. RW Bimby. Oh, I'm not sure that was actually a question there. Clanthith. Oh, FTC PayPal group boycott. Send me on Twitter. That way I can actually collect it. And I'm thinking maybe I'll do a contest off of everybody's who submitted it. So send it on PayPal so I can actually collect it. Sounds good. Special Red Gamer, could being conservative fall under discrimination of creed? The answer, well, the answer is no. There is no instance that would say the discrimination based on your political outlook, political affiliation, or expression is illegal. Now, as I'm saying that, people are going to put lots of comments saying, you're wrong, Lior. We have it in California, New York, DC. Right, California and New York have political, I'm not sure, I don't remember if it's political expression or association being impermissible, discrimination based on that, but only in cases of employment, right? Your employer cannot fire you because you are a supporter of one party or another, or believe certain political ideology than another. In DC, it's different. Obviously a tiny little place, obviously not a state. They do have generalized, unrestricted prohibition against discrimination based on political, I believe it's expression, but could be affiliation. So, but nobody has tested it within the boundaries of DC. So it's potentially there, but nobody really tested it. So there's no legal precedent to go after. I was wondering, Jess Lior. Oh, I think the name was erased here. Lior, I was wondering whether performing copyrighted material in another medium counts as fair use. For instance, singing a song on YouTube, reading a book on YouTube, playing a game on YouTube. The answer is no. And if you saw, I did not stutter. The answer is no. It's I wouldn't do it. If you take, and I have to admit, sometimes I'm watching it. I've told you before that I'm inherently a geek. I like comic books, I like video games, I like, you know, Star Wars, Harry Potter, those kind of ridiculous things. Feel free to put some jokes at the bottom. So I often have seen videos of people basically reading out comic books. That's copyright infringement. There's no doubt to it. The very fact that those channels have not been taken down, some have, but some have not, doesn't change the fact that it's copyright infringement. Because the law basically says that if you've created a product, your ability to basically monetize it through different medium is logical extension, meaning it's kind of built into the law. Just because you have never allowed anybody to read your comic book on YouTube does not mean that it's not a logical extension, and one day in the future you may want to take advantage of it. So it's not fair use. Change of medium is not, it's strictly copyright infringement. Great question, by the way. Fortrend Fiend. Remember to at youtuberlaw. Thank you so much. Excellent. Darius Hutchinson. Are you originally from Germany or Poland? Wow, neither. It's a funny accent that I have, right? Because I'm originally from Israel, but I came here as a little kid, but I came with a very funny accent, and people were making fun of me, so I was determined to get rid of it. Obviously, if I'm living in South Florida, I have two choices, kind of the Florida accent, which is kind of flat without any much intonations in the tone, and a Hispanic one. So as I'm watching and I'm listening to people, I kind of adopted a mixture of those two, which resulted in an accent that makes no sense to anybody, but that's what it is. So I'm from neither country. Beach Geek. What if Twitter banned government officials so there couldn't be a public forum? Might make Twitter a lot nicer place to be at. They could. I mean, under Twitter's logic, they could ban anybody for any reason. So they can ban public officials. I can't see it happening, right? If you saw the Joe Rogan interview with the Twitter CEO, Jack Dorsey, right? He believes strongly that public officials contribute to the discussion. So at least, and I'm not asking you to believe a lot of the stuff he said, because some of this stuff made absolutely no sense, some kind of just platitudes because it sounded good, but I think he was serious about that there's a real value to those public officials, which is why a lot of the celebrities and the public officials, even when they are technically breaking Twitter's rules, they are not getting banned, while you and I would get banned, because he feels they're critical to the conversation and whatever they're saying has value to the audience at large, and that's why he doesn't move against public officials. So they could, if they find, if that ruling stands and they say, you know, all these public officials are creating this little mini public forum, as a result we can't ban anybody. That would be kind of extreme measure. I would think it's kind of throwing the baby with the bathwater kind of response. But I think before that, they would actually try to interfere and join some of the lawsuit to prevent that from happening. As Jar Jar Bing, thank you so much for the super chat. Can Section 230 be used against a protected class? And if so, could a criminal complaint be argued against the companies that do? Great question, right? Hasn't been tested. So let's think about it this way. Section 230 basically says that I'm not liable for anything that you as a user put on. So as a result, I'm allowed to actually remove you. Because if I'm removing you based on your content, I cannot be held liable. So now, what if I remove you and you because of your status? Well, the argument would be that Section 230 doesn't apply for removal based on status, but rather removal based on content, which is why people are always saying you broke the rules. That is a removal based on actual content. That would be a weak argument, saying this is my status, my immutable characteristics versus my speech, what I actually say. So that's probably will not hold. Your biggest hurdle here is that ultimately there is no law that says you're not allowed to discriminate against anybody on website, because discrimination is prohibited when it comes to protected class only when applied to public accommodation or certain enumerated places. So housing or rentals, hotels, certain restaurants, employment. I mean, there are certain enumerated categories in also banking and credit facilities, but those are effectively explicitly identified locations where discrimination is prohibited. There is no general prohibition against it. So if somebody online says, we do not allow women on our site, we do not allow people of a certain age or a certain nationality on our site, you would have a hard time arguing that that is actually breaking the law, because there's no law that guarantees it. The closest you get is a series of cases, and it's not consistent across the United States. So it's really not really what I would say is the law of the land, but it's certain cases that say that websites, when they are a necessary adjunct to a physical store, might be subject to certain restrictions on discrimination, including when it comes to disabled individuals. But that is very specific, so it wouldn't apply to Amazon, but would apply, let's say, to Best Buy, something like that. Again, it's not really the law of the land. So the answer is no. Generally, if somebody discriminated online based on somebody's immutable characteristics and their inclusion within a protected class, that would not in itself be legal. Jar Jar Bing, thank you so much for the super chat again. I'm basing this on left arguing against left. I can see what you're doing. And that's exactly what happened. A lot of time, these logic, when we're talking about the Twitter blocking and everything else, if you follow people that are saying, for instance, that Trump did something illegal, he broke the law. He did something that otherwise he's not permitted to do. It's unconstitutional. Then have to adopt what that actually means, which is, okay, then the entire argument about these are private companies allowed to do whatever they want to is thrown out as well. You cannot have an illogical decision that only applies because you are of the opinion that somebody broke the law. You have to stretch it out and include everybody in every case. And this is basically what you're pointing to as well here, that if discrimination is not permitted, well, what if it's done online? Can these private companies ban you? If they ban you, they can ban you for your political affiliation. Can they ban you for being a member of a protected class? And there is no law against that. Do I think it's moving toward that? I think eventually it's going to be. I think that eventually website will be determined to be a public accommodation in line with certain stores and restaurants, and I think that makes sense. It's just kind of like the law is probably 20, 30 years behind the curve, so it will take it time to catch up, but I think that's where it's moving. But I don't think it's going to be inclusive of new categories of protected class like political affiliation and association or political speech. That will take a lot more. I think that they might move to extend the protection to existing protected classes to certain websites anyway, but not necessarily expand on what's inside a protected class. Rand Paul, thank you so much for the super chat. How much power does a CEO have over banning a user, public or private company? So how much power? He can as much power as the board of directors give him. There is nothing to say that he cannot do it. Absolutely nothing. For that matter, he can do it himself. He can delegate it down to his lieutenant or down to somebody, you know, at the very bottom of a totem pole. Any of that is permissible. They're all acting under what's called color of law. So they're all acting basically within the power of the corporation. So a corporation that bans individual because a low-level employee did it is in the same status as they have if they banned it because the CEO did it. But absolutely, a CEO in a company has the authority to ban anybody off of their platform. 251 Omega. I've heard a lot about 18 U.S.C. 101 Section B, okay to lie to Congress, okay to lie to Congress or to judiciary. Is it why certain liars never pay a penalty, and is it true that anyone can use this law? I never heard of 18 U.S.C. 101. And let me just, oh no, that's not it. 18 U.S.C. 101. B. Okay, let's see what you're saying here. Section A does not apply to a party or to a judicial proceeding or to that party's counsel for statement, representation, writing, or document submitted by such party or counsel to a judge or a magistrate in that proceeding. Well, according to this section, whoever is in any matter, no one who fully falsifies shall be fined under this title. Statements or entries generally, and then there does not apply to a party to a judicial proceeding. That's an interesting thing. I'd have to read it to understand it within context, but it covers, you know, statements that are not necessarily like to your own party, to your own counsel, meaning to your own attorney, that you are, that it's not illegal effectively to lie to your own counsel. But what does it mean that if you does not apply to a party to a judicial proceeding for statement, represented writings, or documents submitted by such party or counsel to a judge or magistrate in that proceeding? So why doesn't it apply? I don't know, because I'm just not familiar with that provision. It's interesting. I wish I could tell you. Generally, why somebody is not fined or jailed for lying in court has nothing to do with that, because I've literally never seen that applied. What happens is that judges in the United States, and it basically are concerned that if they fine anybody because they lost a case, they lied, or something like that, that would actually have a chilling effect on the entire judicial process. Maybe the next guy who has a real legitimate claim will be afraid to bring it up because the guy before you heard that the judge actually slammed down an individual. Because sometimes, I know you think you know what is a truth or a lie, but a lot of times there are shades, right? Somebody thinks, well, it's not really a lie because I think of it differently. I know it sounds like a nonsensical kind of argument. So, but judges are very concerned about it. They are often, I've been in cases where they come down very, very hard on the individual when they feel they're being lied to, but they don't generally take it a next step until they feel that somebody's really trying to subvert their proceeding. So it's usually beyond the idea of just lying in court. A lot of times it's really a subversion of justice that they are concerned about. Jar Jar Bing, thank you again for the super chat. Cannot the argument of conscience be forcibly applied or used as a form of scrutiny, if anything, to force bad publicity on those companies treating it as an online bullying? Okay, cannot the argument of conscience be forcibly applied or used as a form of scrutiny, if anything, to force bad publicity on those companies treating it as online bullying? I'm not sure about the question. I apologize here, Jar Jar Binks. Conscious, be forcibly applied. I apologize, really do. Ask me that question another way, because I'm apologize, but I'm not understanding what the question is. Internet Law Review, thank you so much for the super chat. Any thoughts on El Chapo trial conviction? Not at all. Not the kind of stuff I follow. I do apologize for it. So, an interesting story, the whole El Chapo things, right? It was a couple of years ago when he was caught, but I really haven't followed it at all, so I don't know. John Taylor, is it a valid PR legal move to file a lawsuit or defend a lawsuit to virtue signal, then just put up a perfunctory fight as the coverage is more important than the case? Is it a valid legal move? Absolutely not. It is not. there are certain ethical obligation, and if you are moving forward, that's exactly what you need to be doing. They are, depending on the state bar's actual ramifications for effectively threatening to do something. Now, can you threaten, start, and then fail to finish? Yes. The law is not going to, the bar associations are not going to go after you for that. So the way you describe it is probably no consequence to it, because the concept of what is perfunctory and not would be almost impossible for any bar association, any judicial proceeding under the bar to actually determine if that's what actually happened here. But there is an ethical problem with something like that, effectively threatening with no real intention of following through with that. So, hope I answered that. Kazia Thornhill. Thank you for all your hard work. I'll name my first son after you. Thank you. I hope not. Lior is not a great name in the United States, so choose a better name. But thank you so much, Garrett Claiborne. I always hear about the Ninth Circuit Court. What the heck is the circuit in the judicial system? Basically, our country is divided into 11 circuits plus DC. So it's state by state, they have a court system, but the federal system is divided into circuits, which actually include more than one state. So let's pull it up right now just to see what right. So the Second Circuit will include New York, but it's not just New York, for instance. So here I'm pulling up a map of the different circuits, right? So the Ninth Circuit, and we know of the Ninth Circuit because it includes California, where a lot of the cases that you care about actually happen. That's really, California has been the leader when it comes to a lot of the tech issues, definitely when it comes to privacy. But if you look at a map of what the Ninth Circuit actually includes from a federal court perspective, it includes also Arizona, Nevada, Idaho, Oregon, Montana, and Washington. So it's quite large. The idea being that the entire federal system is divided into these 11 circuits, and there should be some measure of consistency within the circuits and over time across circuits, right? So if you are within the Ninth Circuit, any decision at your level, let's say the district court level or above, like an appeals court, is applicable to you as a potential precedent. If you're in California, something determined in New York is not a precedent, right? So Missouri, what? I'm not sure what we're talking here about Missouri. Here, Missouri is in the 8th Circuit. New York is in the 2nd Circuit. So the decision by the district court against Donald Trump in the circuit is not necessarily a precedent in the 8th Circuit where Missouri is. They can rely on it. Nothing forbids them from doing so, but it's not technically a precedent. The idea over time that decisions are made across the different circuits, and if there are inconsistency, that's when there's an appeal to the Supreme Court, which will hopefully make a decision about inconsistency across circuits. So we're talking about the federal legal system divided into 11 circuits, which makes the running of the federal judiciary system somewhat easier because it's not state by state, it's circuit by circuit. So you got 11 versus 50. Jar Jar Binks, as in treating it more as online bullying be applied and less a speech argument, that is, being bad corporation versus John Q. Little Guy, the whole conscious-based contract. Okay. Okay, you talk about, I think you're talking about unconscionability, not conscious. The unconscionability part, which basically says that certain provisions that are being forced upon you by these corporations should otherwise not be adhered to. The judges should throw it out. So there's a couple of different arguments you're making here. As far as unconscionability, I'm with you on that. I believe that there has been a real change in our usage of these forcible contract, these contracts of adhesion, where you are being presented with a contract and you have no chance to negotiate that. Those used to be up to 20 years ago. You've had maybe 1 or 2 of those in your lifetime, but nowadays you probably sign about 100 of those a year, because every website you go on is subject to this kind of a contract of adhesion. It's my contention that we need to bring back the concept of unconscionability, which really has been kind of dropped by the court system when it was, in fact, you know, a very rare thing to see contracts of adhesion. So right now, it's really not applicable. For that, you have to make some changes in the state law to really force the courts to apply the concept of unconscionability to those agreements. Now, let me go back here. Now the question is whether or not these platforms are not expressing their right of free speech, but rather are bullying the individual, right? So when they go after you and they deplatform, are they harassing you? Are they annoying you? Are they basically breaking the law? In this case, you're talking about state law. You could try. The problem is that free speech is going to trump any sort of state law dealing in bullying. The idea that I'm permitted to express myself would often be a hindrance to a case when it comes to harassment. And if you actually follow just normal cases of harassment and bullying, these are happening on a state level, they generally fail. Because in the United States, we believe so strongly in free speech that it's very, very difficult for the courts often to say, you know what you said is not subject to free speech protection, but it was somehow bullying. See, the courts can see it when you're inciting, when you're telling somebody to attack, but calling people names, that's generally is protected under free speech. I can call you names, I can call you terrible names. It can be insulting, it can hurt you, but generally that's not against the law. And so the state level cases when it comes to harassment have not generally been very successful, because it's very, very difficult to justify telling a court that they should stop somebody from speaking because it has some injurious impact. Which, if you turn it around, because you were trying to, I'm assuming you're trying to say that these platforms are actually injuring the user by banning them or saying things about them. But in fact, I think it's the other way around. It's these platforms who have adopted this notion that your speech is somehow harassment, even though the law would not have considered a lot of what people said to be harassment. And so they're creating their own definitions, often very, very loose definition of what harassment is, and is applying it and actually just throwing out any notion of free speech. So it's kind of been turned on its head in the last 10 years by these platforms. Michael, oh, I can't pronounce that name. Sorry. In South Africa, we don't have hate speech as a concept, but we do have a crime called crimen injuria, which is injuring someone's dignity. Does US have anything similar? Generally, no, with the exception of defamation. Because, yes, if I lie about factual matters related to you, I can be sued for defamation because I injured your reputation. But in the United States, it's very narrowly applied. Some other countries, defamation is a much broader concept. In the United States, it's really only about statements of facts. So I can call you name, even names that are associated with facts, like calling you a thief. You say, well, isn't that defamation? I've never stole anything, and I've never been prosecuted, never been convicted. Yeah, but it's kind of a colloquial name. It's not alleging specific facts. If I said, I know that you stole money from your grandmother, that's actually statement of fact. It could be the basis for it. So the answer is yes, but very, very limited in the United States within the concept of defamation. Jar Jar Binks. Interesting. So sexual innuendos is usually interpreted harassment, but general verbal harassment is not. Okay, so now you're dealing with something, a bunch of different things here, that laws which requires companies to effectively protect its employees and how it's applied within those companies, and whether or not sexual innuendos, which is when expressed by people above you that have a certain level of control or influence of you because you're your boss, whether or not that's actually permitted. You have to understand that there are circumstances where language, because of your relationship with the individual or your position, can actually put somebody in fear of their life, or in fear that something will happen to them. And that's different, right? We're not talking about that. Generally, speech online, even if you feel fearful, the law does not recognize that there is legally a rationality for your fear. You might actually feel it, but there is no imminence to it. If I'm somebody's boss and I'm threatening them, or even through sexual innuendos, arguably, because of my proximity, because of my influence, because of my position here, there is a much higher level of rationality to you actually feeling scared, or the likelihood that you're going to be harmed. Something that when done in a distance simply does not exist. You have to think about it kind of like the issue with incitements, where it's not enough to say that let's go and burn down a place, but let's do it now. Let's right now meet at the corner. Let's beat up that guy. That gets you closer than a general statement being made. So you have to understand, at the end of the day, that the United States, we respect free speech so much that we allow language that is otherwise hurtful. And we say that it's okay often because, you know, it is part of society effectively, that injuring people through our speech, while nobody minimizes the harm to it, is not something that somebody would feel within fear of their life, because usually the proximity or the likelihood that is happening, geographical proximity, relational proximity, whether or not they have a certain amount of influence or control over your life. So those are the kind of elements that courts take a look into to see whether or not a general threat should be considered illegal because it's somehow harassment, although harassment is a bad term because it's so ill-defined under the law. Jar Jar Bing, losing your platform fear is losing your livelihood, especially if you're making good online money. I agree, but that's not going to be enough. I'm sorry. I mean, I'm with you on the idea that something needs to change and there are real legal solutions to it. I don't like messing with free speech because we are all the beneficiaries. I don't want to pursue actions that then say that certain actions are basically exceptions to free speech. I don't want to look for exceptions to free speech and say, you know what, when a platform is going after my account, that's harassment. When they are extending their own biases or their own political or social position, that's harassment. I think that we can find legal solutions that does not betray the companies or the individual's right of free speech, while still protecting the individuals and their own personal property, their right to make money, their right to their own content, their right to speak to others. I think that there are solutions here, and that's kind of what we're working on, that there is the next step, the next solution to the kind of project we're working on beyond the antitrust that we're doing right now. The idea that we need to rebalance the power through the contracts of adhesion, through your terms of service and such, not touch on free speech, not weaken free speech, not develop exceptions to free speech, but respect free speech, but I understand that contractual relationships nonetheless can be altered and the balance of power can be changed through those same contracts. Jar Jar Bing, thank you for the super chat. Oh no, that was it again. Sorry. Great. Second Fleet Actual. Don't feed the troll even if it's a super chat. There hasn't been a question that I found objectionable in any way. Chris Bethune. Room for Congress to regulate payment processors so that they can't ban access on their, I don't know, NW via the Commerce Clause. I struggle because some say no, but I see precedent even in Federalist Papers. They would have... There is no general ban against discrimination when it comes to credit facilities. There are bans when it comes to specific protected classes. That's in contrast, let's say, to certain common facilities like, say, water and electricity, where that would be prohibited based on, short of you not paying your bill, you would not be, discrimination based on the content of your speech would not be permitted because of the necessity of that facility. Nobody has yet made the argument, maybe they should, that credit facilities rise to that level. People now are arguing that whether or not the internet is such a level. Can companies discriminate and not permit you entry into the internet through their portal because of your speech? Is that permissible, or should we consider all internet access to be basically an essential facility through which people should be allowed to enter regardless of the content of the speech, short of them not paying? So I see what you're saying, but that argument has not been made, and the law right now does not support it. It basically only supports specific protected classes against discrimination. M2HMGHB. Due to the size and powers of corporation, do you think that political speech should become a protected class of speech? I could tell you that there's no political will to it, and a lot of people that are opposed to any sort of online censorship by private companies are also not in support of adding to the protected class. I think that that would be a short-term solution, saying that political speech or political affiliation should be a protected class. The problem is that does not solve every problem, because it then becomes, well, I'm not actually banning you because you are conservative. I'm banning you because you are calling for the deportation of individuals, and that is harassment. You would say, well, it's my political belief, and they will say, no, it's actually harassment. And there you get into those arguments, and then basically it comes to a point where people are searching for little loopholes in the law to advance their beliefs here. So I just don't think that a protected class here in this case would solve the problem in the long term. It kind of be a quick fix if the government could actually do it, but I don't think it's a long-term solution. I think the long-term solution has to be the rebalance of power between platforms and individuals. Respect to free speech by rebalancing it through state-level contract law that say that certain procedures are required to be implemented. Otherwise, the provisions as provided by those contracts are unconscionable. I think that's a better way of regulating the law, requiring there to be a process, a procedure that requires these platforms to identify anytime you violate anything, give you an opportunity to cure, not an automatic termination, and gives you a way, even once terminated, a way of actually returning based on specific rules. Something that would be in existence in a negotiated contract, applying the elements in a negotiated contract to these contract of adhesion, the terms of service, the privacy policies, which are never actually negotiated. during 1804, so theoretically a bank could legally ban someone from using a bank for being a Democrat or a Republican. The answer is yes. Sounds terrible, but there is no prohibition against discrimination for being a member of a political party. Sweet old man. If someone leaks classified information, the information is still classified, so it's illegal to share. Potentially, it's illegal to share. There's definitely been circumstances under which classified information has been shared, and the sharing is not illegal. It's often left up to the newspapers to make some decisions about the proprietary of it or not. If that was the case, the government would make everything classified, and often they do, and that would never allow citizens to actually learn about the inner workings of the government. You can see how that is problematic. If you follow that, that gives the government tool to make sure that you never learn about things, because all they have to do is classified. And often the argument is the classification sufficient? Is that information really such that it would cause a certain level of harm? Probably all exposure. You have to understand that revelation that somebody revealing all your personal emails will injure you. The question is, so what? Is that sufficient to, because you put a classified stamp on it, to actually prohibit it from being shared? Not necessarily. So there's the argument. Somebody would have to make a much more detailed argument when it comes to Assange that the specific information he exposed was not harmful because it embarrassed or it exposed certain things, but actually put specific people in danger, and it was something known that the release of that information actually put individuals in danger, individual project in danger, things that actually were harmful to the country. And I'm just telling you that I don't know enough of those details, and that's why I was saying that I don't know the illegality behind it, because I'm not sure about specific items that were released that ultimately put individual lives in danger. Rand Paul, thank you so much for the super chat. Was there a time when a company did not have the First Amendment right, and if so, when and why did it happen? Absolutely. If you follow the history of America from before it was a country, corporations were essentially at the heart of what the country was about. The first settlements in the United States were actually corporations, chartered organizations, and they were given permission, and they effectively ran themselves like cities. A lot of the original colonies were in fact just corporations where people actually worked for them under a charter from the British government. And over time, you see over 200 years of time, as American citizens over time gain free speech right, because until really the 1920s, we didn't have any real body within the government that really championed free speech. It was something the Americans determined and often kicked out politicians who did not support it, but the court was not a fan of free speech, not as we know it today, definitely not the president nor the legislative. And so starting with the 1920s, what you see that every time there was any sort of step forward for free speech, it was always challenged by corporations who sought to extend it to them as well. And so what you end up being is small little decision over time, no monumental decision. There have been some real monumental decision when it came to individuals and our right of free speech. But when it comes to corporation, it was just a series of small things that extended, that drew the logic that an artificial entity should be entitled to the same rights as an individual. And there was an argument at the beginning of why would a company have those rights? And there was an argument, is it because of the individuals who own it or the individuals who run it? Or is it actually a right associated with the artificial entity and it's separate from the individuals who own it or run it? And there was an argument for a long time, which logic actually is it? And in many ways, you can understand when courts followed the idea that the rights of the corporation derive from its shareholders, from the people who own it or from the people who run it, that made sense to the court. And they extended the rights of free speech based on the idea that, well, if the owners have it and they want to express it, their own opinion from within the corporation, they should not be prohibited from doing so. But then there was a switch and the court dropped. See, it accepted the idea of a corporate right of free speech grew out of those kind of arguments that it derived from the rights of the individuals. But at some point, basically, that logic was dropped and the courts continued to accept more and more cases saying that even though that's what got us here, now we're going to associate the right strictly with the artificial entity and not because of the individual who own it or run it. So it was just remarkably small little steps along the way that gave corporations rights, and eventually it separated itself from the individuals who run it or own it. So no real monumental effect. I mean, look, Citizens United was an unexpected win in favor of corporation. It was completely unexpected and often illogical. But really, the getting free speech for corporation was just tiny little steps that nobody paid attention to because nobody went back to the 1920s and told, do you think that these artificial entities should have absolute right of free speech? Every single court would have thrown you out, probably laugh at you. It's just tiny little steps that nobody paid attention to, and corporation kept increasing their rights of free speech in small way that over the span of 100 years really changed everything. Derna 1804, when I got a security clearance when I was in the army, I had to sign an agreement to adhere to the clearance. My understanding is the legal basis for clearance is contractual. Oh, I agree that whoever releases information is breaking the law. Now, there are exceptions to it dealing with whistleblower. You have to understand it's not... So, yes, if you join a corporation or you join the army or any sort of secure organization, you're going to sign an agreement not to share. And if you do, those organizations can sue you, in some cases jail you for it because of the risk that it endangers. What you find is also laws designed to protect those whistleblowers because the law also recognizes that we all as a society benefit when a lot of these secrets, these classified secrets, are actually leaked, that there actually is a benefit here. So the law has to balance potential harm to the government that should not be associated with embarrassment or basically making life a little harder, but rather be really dangerous to the individuals or to the operations, versus we benefit when people actually reveal that unsavory things are happening within the governments or within the corporation. So there's a balance to be had that the courts try their best to do. A sweet old man. According to the professors of the security classes I have taken, I'm not sure. Oh, was that the prior? That might have been the prior, an extension to the prior comment. I apologize. Tiny Fata. I just got here. Forgive me if there's been answered already. Has anybody tried to contact you to try to get you to stop your attempt at filming a complaint over the Patreon thing? The answer is no. I haven't heard from the companies. I don't expect to hear from them. It is if you know that somebody wants to file a lawsuit over it, you might look to settle the argument, right? So generally, you try to. In this case, these companies are not likely to seek a settlement because I don't see this as something they want to move away from. There's a certain level of market power that they exercise that I don't think they would willingly relinquish unless forced to do so, unless it's basically exposed to the light. So could there be a settlement here? Of course there could be a settlement here. If there's an agreement to stop collusive behavior that undermines competition, that actually prevents people from speaking on alternative networks, then there could be a solution as long as there's certain security measures are put in place to make sure that this actually happens. You know, trust but verify kind of ideology. But there could be one. I just don't see it happening absent scrutiny by the federal government. There might be a settlement, but I don't think it would start until the FTC started looking at it. In my opinion, not until the FTC recognizes that they need to actually start a formal investigation. That might open the door for potential settlement, but not at this stage. TRDI. I think the Twitter CEO might be okay with the decision. He expressed an opinion that they don't have the right to ban Trump because of his position. This goes hand in hand then. See, the way I heard what he said is that he did not agree that they don't have the right. My belief is that no CEO of any major platform will ever say we don't have the right. They assume that they absolutely have the right. They choose not to because of the value. So he was actually talking about banning Trump. He's talking the question posed to him, and I don't know the truth of that question, so I can't even answer that. The question was posed that that there is proof, I don't know, that Trump violated the terms of service of Twitter. Why wasn't Trump banned versus everybody else getting banned? And the answer was not that they don't have the ability to do it, but rather that there is value to the speech of an official, specifically the president, but other officials, and because of the value of that statement to the general public, the importance of those statements to public rhetoric, they made a decision not to ban. So I don't think that they will be in line with that decision. At least my perception of it. Darius Hutchinson, thank you very much. Thank you. Tarek Shaban, what made you start this channel? Oh, good question. Inherently, I'm an incredibly shy person, right? I mean, but I always thought that once I get on camera, that would make it easier for me to do so. So, if you were at a company and you relied on people to develop business by going into cocktail parties and talking to everybody, you will not be choosing me as the guy to do that because I'm uncomfortable in those situations. But I always thought that I would absolutely love being in front of a camera and talk. I thought this would be a lot more natural to me. So going through my mind and seeing the development first of podcasting years ago and then of video, I always thought that I would enjoy the process, given the fact that in other circumstances, social circumstances, I'm a shy individual. So that was the first inkling that I wanted to do this. I didn't know what I was going to do. I didn't even know it's going to be about law. I didn't have a concept of how to do it. That came later. But the initial desire to start a channel was because I thought, and I don't even know what made me think that this would be different. Then here I'd be able to express myself a lot better than I do in a social environment. Darius Hutchinson, what law do you specialize in, and what is the title of that white book behind you on the shelf? Excellent book. It's called We the Corporation, which is the answer to that prior question of how did the right of free speech develop for corporations. That's pretty much it. Now, you have to be willing to read through a lot. It's dense. It's an outstanding read when it comes to rights of free speech for the corporations. Literally take you from colonial time to the present day to really see how free speech developed when it comes to corporations. So it's a great book. Hard. I actually did not read it. I actually then ended up buying it on Audible. It's not a promotion here. And because I drive like an hour and a half every single day, that's how I won't say I read it. I heard it. So, but it was actually the subject of a sweepstakes a few months ago, and I believe the winner was out in Australia. I believe I sent it out to. On what law? I call myself a tech lawyer, which is basically I represent technology companies. So it's a combination of corporate law, intellectual property law, a lot of what would be considered advertising law. So I work with tech startups, and anything from forming them to helping them raise money to bringing their mobile apps or their website into legal compliance. So I drafted hundreds of these kind of terms of service and privacy policies and all the rules, everything that most of you absolutely hate and complain about. I'm guilty of writing many of them. It's just there's legal reasons why they're written that way and why not. But that's essentially what I do. I represent tech company through their lifetime, from formation all the way to their sale. LAOs, I think that's what I say. What would be the legal barriers to entry for a potential YouTube competitor? Do you think these types of obstacles are preventing a genuine competitor from rising? Well, I think that if you think that the competitor would look like YouTube, then there's a massive barrier to entry, which has to do with money, the ability to create the foundation to run basically all the computing power and the bandwidth to run these videos, and not only upload them, but then actually basically transmit the information and then build the organization that can support it, given all the legal requirements, at least around copyright. It requires massive investment and a commitment. So there are not many companies who can step in there. Amazon can step in there. But you need that size company that can put that kind of investment forthwith. So if you're looking for another YouTube that looks like it, I think that that ability to actually grow is very limited. Could happen, but I think it's always going to be a niche, because they will never have that kind of money, that kind of capital to really compete with YouTube on that kind of scale. I think that the competitors are going to look completely different. Facebook is not facing competition from other social media. There's not going to be another Facebook. A new, MySpace is not going to rise up and topple Facebook. The competitor is going to look different. Who had a real chance of toppling Facebook? Instagram. That's why they bought them. The recognition that Instagram could have killed Facebook, because ultimately there was a realization that what people care about most are the pictures. Some commentary, but mostly pictures. And they care about it mostly on a mobile platform, far less on a computer. And so the competitor is going to look differently. And there have been definitely potential competitors that had a potential to grow. Mobile apps that focus on tiny little snippets of video, or other ways of delivering the video itself. So it might be through a mobile only, but it might be something that basically we haven't thought about. How do you deliver a visual and audio experience without having to provide the entire infrastructure to it? And it might be by actually controlling the size, and we've had those before, down to very short snippets of video rather than the long form video. That might be the kind of competitor that can actually topple YouTube. Obviously, some have tried and failed that. But that's what I'm thinking. A successful competitor is not going to look like the existing reigning monopolies. It's going to look very different, which will initially, these monopolies will not consider to actually be competitors, but over time, they'll be able to exploit a certain weakness in those large networks and actually build a following off of that exploitation. Jar Jar Binks, then why be told to take an oath if there's little chance it will be enforced? Why? It's not a question of it not being enforced. The question is when it should not be enforced, because the lack of enforcement is actually beneficial to society. When are you a traitor versus when are you a whistleblower, identifying basically either officials breaking the law, individuals breaking the law, harms to society or to individuals that is happening behind closed door that otherwise is being prevented from coming to light because of all of those kind of agreement that force you to be quiet. So society just has to balance it, and you can understand how important that would be. that just because somebody signs a contract does not mean that they should never speak, even though there might be harm to individuals. Imagine if you work for a chemical company who's dumping chemicals into the water and killing children. Should you not speak up because you're under a contractual agreement to keep their secrets? I would hope not, and I would hope that the law would actually protect it. And the same thing when it comes to the military, just because they actually say that it's classified, and guess what? They say everything is classified. What the general might be eating for breakfast is classified information, but sometimes you find out that there are actually violations of the law, harm actually being perpetrated against individuals. And if individuals don't speak because they are subject to prohibitions, then we are all worse off. So that's why the law has to balance them. Thomas Key, I joined your legal team today. Oh, awesome. I'm excited to help the cause. Do you recommend I pull my Horn books or sources from the library to prime my research? I don't know if you right now need to prime your research. I think that it'd be helpful if you caught up on Section 1 and Section 2 of the Sherman Act. Those are the two big ones, although we are pursuing claims associated also with 2 other acts, but to understand how it operates and how you build the case, definitely there are some great treatises on what it takes to build a Section 1 and Section 2 Sherman Act case. I don't know from that name, but if you would like to, send me a DM. We'll set up a time. I'll talk to you, and then I can introduce you to some of the attorneys, and we can go from there. Unicorn Sprinkles, don't forget to click like. Thank you so much. Benjamin Barber. Any opinion about California Constitution free speech, lack of state action requirement, and the Unruh Civil Rights Act construed by California Supreme Court as banning all arbitrary discrimination in business? I don't have any real opinion on the matter, except that nobody's been able to effectively use it as a ban against discrimination when it comes to online platform, because they never got past either Section 230 or free speech requirements. And since those are on the federal level, they are effectively usurping the state law, which this is what the Unruh state law, which prohibits discrimination, because Section 230 pretty much provides a blanket immunity about you taking action against users based on their content of their speech, essentially. And if that is not sufficient to actually get the case dismissed, then it's about federal rights of free speech, constitutional right of free speech, that these companies are expressing their right to disassociate with individuals. So people have hoped that the Unruh Act would be a way of actually stopping discrimination on these platforms, but it just hasn't. And I'm not sure if, I just don't think it's going to work. Something else is needed here, but, and in my opinion, it's not going to come in the form of state law that prohibits it, absent the idea that you're creating protected classes and you then add website into the concept of a public accommodation. You can do that at a state level and that would fix it, but not this kind of a law like the Unruh Act. M2HMGHB. Man, love to know what that stands for. Regarding the Second Amendment, one argue is that it solely encompasses the militia. 10 U.S.C. 246 defines militia as any able-bodied male between 17 and 45. Just something interesting. I'm generally of the opinion that we as Americans are entitled to do anything we want to that in itself is not harmful to individuals or society. And that goes beyond the Constitution. And I think that the law all too often decides to tell us what is good for us. Now that can lead to strange arguments. I think that we are allowed to mess up our lives. We have rights to do things like, do things that are terrible for us, from doing, very dangerous sports to taking drugs to, because it is only ultimately harmful potentially to us. And I think the concept of guns society may not want guns, but the reality of it that as an American, your ownership of gun is not in itself does not in itself create a problem. You're not putting anybody in danger because of your ownership or your usage of gun. And the idea that the only solution to it is actually the banning of gun. If you want to ban violence, you ban the instrument of it. Makes no sense, because it's like saying that we need to reduce death associated with cars, so let's ban cars, rather than, well, can we put in some speed limits? Can we make sure that people put on seat belts? Can we maybe have education when it comes to how to drive cars? So I think that often when it comes to gun, it's a bad solution to a complicated problem, but it's just easier to say it's all about the instrument rather than it's about human behavior and our difficulty in dealing with that. The whole Second Amendment issue is obviously very, very different, whether or not beyond that issue, beyond the concept, which is what I'm talking about, which is essentially our freedom, our right to do as we wish to, as long as we're not harming anybody else. Whether or not it's a guarantee, I'll leave it up to the Supreme Court. And the Supreme Court has said 100 different times that it's our right. It's not associated with a militia. It's actually a right that we as Americans have. And if I'm willing to accept laws that are either agree with it or disagree with it, I think that is the law of the land. And I don't see a point in continuously arguing and trying to reverse a decision that has been reiterated by the Supreme Court many, many times. I think that it's simply a right that Americans have, and people that disagree with it, well, I'm sorry, but it's too bad. We need to focus on the solution, not on the instrument that are used as part of some problems. Cons Clan Sith. Have you seen the notices for the lawsuits by the Covington kids? I heard of them. I haven't really seen it. I think that we've spoken about it. I think that it was not unexpected, largely because in the beginning, I would say that a lot of the videos, a lot of the commentaries would probably fall under free speech, more of opinionated, but it became very, very clear and very quickly that what was described or shown to us was actually a false story. That actually, for something as specific as whether or not the kid walked into a group of protesters, or was the protester walking into the midst of a group of children, that makes a big difference in what was said and what was not said. It was very, very clear very early on that the original stories were false, and the reiteration of false information once known actually did cause injury. So I think those can serve as the basis for defamation. I'm not saying this is easy. Defamation lawsuits in the United States are very, very difficult, but I think expected. Jar Jar Bing. Okay, that makes more sense to me now. I've been wondering about that for years. I'm still a bit miffed at the left, and I'm not trolling. I'm actually curious. I didn't think for a second you were trolling. I was very appreciative of your question. So thank you very much. Derma 1804. Does speech have protected classes? I thought that concept only applies to identity groups. No, that's the whole point. The idea is that you could add speech as a protected class. Political speech, political associate as a protected class. You could do that, and then you would also have to then say that you're not allowed to discriminate on website, effectively making a website like a public accommodation equal to a hotel or a restaurant. But no, today they're not a protected class, so it's not something that's relevant. I'm just saying that it's possible that this is one solution to it, to actually identify certain associations and certain elements of speech as being protected. A sweet old man. Worth noting that Don't Mind Me has brought up some good counter-argument to what I had said in the comment I tagged you, making a similar argument to what you made. Yeah, if somebody makes a great argument but doesn't actually put at youtuberlaw, I don't see it, so that's the problem. Great arguments, but if you want me to respond to them, you gotta tag me in it. Cons Clan Sith. The WikiLeaks releases got US informants killed. You know, that's where the argument would be. See, again, I don't know enough of the details of what actually happened and what information and whether or not that was a foreseeable consequence of publishing something like that. But there's the argument to be made here. If there was a known information that was going to lead, like a revelation of certain people that were undercover in different countries, and you were revealing it and you were putting their lives in danger and potentially having them killed, and that you can see where that would trump any sort of right for the leakage of information. But that's the balance ultimately. Nathan Danner. Is the Texas ban on Israel good boycott a violation of free speech? How would they even force people to buy Israel product if they don't want to? Texas, okay, so I'm not aware of the ban and how it's incorporated. Usually the bans have to do with, you know, government not buying certain products that are produced by certain countries, or in Israel it's usually a category, a certain region within the state. Is it if the state told you cannot buy a product from a specific country, is that a violation of free speech? It's definitely a restriction on your right of free speech. But then again, the federal government does it all the time. They ban the importation from specific countries that is identified as being a risk to the country, such as, you know, North Korea, Iran, Venezuela, stuff like that. Actually, I don't think Venezuela is included, but other countries like that. Cuba was on that list for a long time. I don't know if it's still on it. When it comes to the boycott of Israel, it's different because that is an element of speech. It's nothing to do with the risk to the country. It's more about trying to voice an opinion that you're in opposition to the Israeli position vis-a-vis the Palestinians. So I see your point, but as I'm talking through it, I think I'm going to withdraw from that conversation, given the fact that I'm obviously from Israel. I don't want to introduce an argument to which I'm probably inherently biased in one way or another. So it's probably not going to be kind of an unbiased argument on my part. So when it comes to that, I'm going to withdraw my opinion, let other people comment on it rather than myself, because I'm not sure I can provide an unbiased opinion about this stuff. I apologize. A sweet old man. I finished We the Corporations today. To what extent do you think corporations should be able to fund political campaigns? Oh my God. I think that there should have been enormous restrictions on corporations. I think at most corporations should have been facing the same restriction as an individual, that a corporation is no different than a single individual. So if an individual has, you know, and depending on where you are, they are locally here. I think in the municipality where I live, I think the restriction on individual might be something like $500 or $750. I think something like that. Maybe I'm completely off. Maybe up to $2,500. But I think that a corporation should face exactly the same restrictions. So even if you believe that corporations should be entitled to absolute free speech rights, like an individual, never allow the corporation to have rights greater than. And that's effectively what has happened through the law, that in some instances corporations have far greater rights of free speech because their ability to fund political campaign or political speech or speech in support of political campaign is unrestricted, unlike an individual that still would be restricted from it. So that's where I'd want it. It's not a question of, to me, it's not about making them less than an individual. I'm willing to accept the fact that for historical reason we equated the two, but I think we have turned the corner and now corporations have basically greater speech rights than the individual. That makes no sense to me. Garrett Claiborne. You established that YouTube's TOS can make it a public forum. If I want to make a platform which is legally bound to free speech, can terms in the corporation bylaws be strong enough? No, because bylaws can be amended at any time. It's not as if you can set yourself up basically with a constitution that's very, very difficult. I mean, you can obviously make it so it's difficult to amend the bylaws, make it, you need 80% majority of all shareholders, and if you have a lot of shareholders, that can be difficult. So you can make it more difficult, but that's how it would be. I mean, if you start a company, usually you have very, very few shareholders, so those restrictions are not really meaningful. But yes, you can set up a corporation, and through their bylaws or through a shareholder agreement, through basically all the instrumentalities that actually govern the company, you can put a lot of restrictions that would prevent you from making changes very easily. And then you say that one of those restrictions, the idea that you respect free speech and you follow precisely the guidelines of free speech as, let's say, the US government, and you do not stray from it. And then at that point, the argument would be that not only have you adopted it, but you can't easily change it because you put that restrictions into your bylaws, into your shareholder agreement, into an operating agreement, depending on the type of company you've set up. So it's possible to get there, but you're never going to be quite there, because still in a corporation, there are circumstances in which you can change the rules, or, buy out all the shareholders, or take a company that's public, take it private, and then make changes to, or basically try to pass new bylaws that completely contradict the old one. So there's ways around it. So it's very, very hard to really create a public forum that is not susceptible to changes over time because shareholders want it to be changed or the new CEO want it to be changed. The opinionated one. Is Minds a viable competitor? They seem to be playing a long game. That's an interesting one. I can't say that I have a complete opinion about where it's going. I find it very, very interesting. So I'm intrigued by Minds right now, but I don't know if that's the future. To me, it's different enough that it's a potentially viable competitor to all of these. It's kind of a combination between social media and Medium. So I'm intrigued, but I haven't yet figured it out enough to figure out whether or not this is the future. Tarek Shaban, keep up the good work. Thank you so much. Black Leaf, I know everything about the Second Amendment. I'm sure you know a lot more than I do. Thank you. Joe Vlogs, if you can't drive a car without insurance, would it not make sense to require insurance for guns? A gun held in a secure room would be afforded lower insurance premium. Well, I mean, you are actively driving a massive steel box through intersection where people are walking. Within seconds, the damage to human life would be enormous. I mean, it's a miracle that we are surviving. Get yourself on a highway and think about that. You are in this steel box driving 70 miles per hour and everybody else is doing it. And people have a problem. They got into a fight with their girlfriend. Their team just lost in the Super Bowl. Their boss is being nasty. It's hard for them to concentrate. There is real danger in that. The question is there an inherent danger that you need to provide insurance against based on ownership and usage of a gun? Now, at some level, you can argue the question is it great enough? And I'm not sure that it is. There's ownership of a lot of things that don't require insurance. Me carrying a gun, right? If I have a concealed weapon and I'm walking around, that's not equivalent to me driving a car. Because the gun is in the holster, unless I take it out, there's zero danger in its usage. Unlike a car where I'm literally driving it through intersection where people are crossing every single day. And the slightest look to the right or left can cause people to lose their lives very, very quickly. So I'm not sure if there is a justification for insurance. You have to understand at the end of the day that I would think that most gun owners are covered by insurance through their homeowner's insurance, or by either because it's already part of it or because they get a rider, essentially pay extra to have it covered. So, but So I'm not sure that it's needed, unlike automobiles that are not covered. So most of the time, if I'd have to check. I think that guns will be covered by your homeowner's insurance, but you asked the guy before because he probably know about it much more. People that that know a lot more about gun laws than me. Benjamin Barber. 47 U.S.C. 230 C2A immunity only applies to good faith, and if defendants are discriminating under Unruh Civil Rights Act, does that preclude good faith immunity defense? No. 230 C2, let's pull it up, is not restricted by good faith. I know it's written that way. It's not. Courts have already looked at it this way. Let me take a look. I apologize here. C2A. Okay. A, B, C. Right. Protection for Good Samaritan blocking and screening of offensive material. So you have to first start with no provider shall be treated as a publisher of any information published by another. So general immunity, whatever you're posting, me as the platform, I'm not liable for it. But it says in number 2, no provider or user of an interactive computer shall be liable on account of any action taken to enable or make available to information content providers or other the technical, you talking about A or B? Oh, sorry, you did A. A. Any action voluntarily taken in good faith to restrict access to or availability of material that the provider or user is considered to be obscene, lewd, lascivious, filthy. Okay, so the courts, when they reviewed that language, say that it doesn't really matter because everything hinges on the phrase otherwise objectionable. So because there is the inclusion of otherwise objectionable, you can argue that something is not lewd or lascivious, and you can maybe apply good faith to that because those are terms that have been defined over time by case law. But because the law includes otherwise objectionable, that pretty much means anything. As a result, there is no practical way to apply good faith to that. You are pretty much allowed to ban anybody for any reason otherwise objectionable. Anything that I find objectionable, there cannot be bad faith in what I consider objectionable. So the good faith really applies to the prior one, the enumerated things why people can block you, like being lewd, lascivious, stuff like that. But since most people claim that they're blocked under the otherwise objectionable, which covers anything, good faith is not really applicable there. Jar Jar Bings, I mildly disagree. Someone takes your gun from you. Right, so there's a risk that somebody takes your gun from you. That is always a risk. That less of a risk when it comes to a concealed weapon that has not been drawn. But, right, once, I guess you can get pickpocketed, and I guess you can draw the gun, at which point it's taken away from you. So, the argument is that in the process of somebody taking your gun away from you, somebody else would be liable. I mean, somebody else can get hurt. I would think that this would be covered under the homeowner's insurance. And me personally, let's say I don't own a home, and let's say I don't have a house or I don't have homeowner's insurance, I would personally want to have insurance to cover something like that. But should the law force people to have insurance because somebody might steal your stuff and use it to injure other people? That really stretches the argument, because you really have to argue, well, how about everything else? How about if somebody steals my car and injures people? Am I liable? Well, there could be some circumstances if there was a cause, the reason why I lost the car, maybe I was drunk or something like that. But generally the answer is no. So to hold you liable because somebody you actually carried it lawfully, somebody stole it and hurt somebody else. That's a real stretch. And the fact that you would then need to carry insurance to cover that, I think that probably that's kind of a stretch of the law. You'd have to argue that either the carrying of guns is somehow inherently dangerous, and I think that's a losing argument, but you can say that usage of gun is dangerous. So even lawful usage, like going to a target shoot, is somehow, target range is dangerous because you are dealing with live ammunition. As a result, you should be carrying insurance because there is a risk of danger. That's the kind of argument you would have to make, that there is inherent danger in using a gun, regardless of the intentionality under the best circumstances. I'm just not sure that there is enough data to justify that there is enough accidental shooting that would require that. But what people are arguing is that really it's going to be used in violence, but that's not attributable to the ownership of gun as much as a particular usage of gun, which you can't really insure. So I guess I would have to think about it more. I don't see the argument for it. I don't see how that helps. I think that I think that gun owners will want to carry insurance, but whether or not the law forcing it, I don't think that changes anything, except it forces people to bear increased expenses when it comes to that, which is another way of restricting their right to actually own, because you've now increased the cost of it. No help, nope. Hope you and Sprinkles had yourself a good night since last week. We did. Yeah. When we learn to focus on what's in front of us, do work, try to forget, watch something funny, that's when you have a good time. It's hard to live inside, when somebody so close to you dies. It's hard to live in that world for a very long time, so you find solace in the mundane things in life, like working and doing basic chores. That in many ways is very, very helpful. Understeer Extra. A YouTuber I know was terminated for no reason and only violated TOS once. He was mass flagged by a group of fans. Other YouTubers have sued YouTube to get their channel back. Would you be able to file a lawsuit requesting YouTube to unterminate the channel, like it has been reported on Drama Alert for other YouTubers such as Derv? I told him, such as Derv. I don't know what Derv is. I told him about the price for consultation, but he didn't know if it was worth contacting you about. Okay. So let me save your friend money. There is no chance of winning under the current state of the law. No chance of winning a lawsuit that says you must basically reverse my termination. Now, YouTube may terminate you for violation of the terms of service, but they can effectively terminate you for any reason whatsoever. That's really the law. So, and their terms of service actually has that. If you start following every single terms of service, it always lists reasons for termination, but always keeps a provision, a section in those terms that say that basically we can terminate you for any and all reason at any time by giving you, simple notice. And that basically is their get out of jail card. They can terminate you. And once they can terminate you for any reason, they're not really restricted just based on violation of terms of service, then they can rely on Section 230, which is an absolute immunity. So a lawsuit to reinstate is just not going to be successful. I'm sorry. The Derek Ruby Show. How does it work when a UK court rules you cannot identify certain individuals who committed crime when they say it's a worldwide ban? What if someone in the US does it? It has no bearing whatsoever. Couldn't care less what the UK says, that we are not, that somebody like that is not identified. It actually would be against the law in the United States, and the United States have a specific law that forbids that kind of a foreign country from pushing their anti-free speech laws on American citizens. So it has no real bearing. Free speech restrictions are really geographical in nature. So unless there's some sort of agreement between a country that will respect it, it will not be valid. And the United States does not respect any kind of anti-speech laws that outside of its own borders. It simply does not. It respects free speech too much so that it does not. There have been many of those kind of lawsuits out of the one that comes to mind actually is out of Australia, where a citizen was actually sued for speaking in violation of Australian law, and the Australian court then issued an order that will allow the plaintiff out of Australia to come in and claim damages in the US, and the US threw it out. The US is not going to respect anti-free speech laws coming out of any other country. Jar Jar Bing, thank you for the super chat. I think we need to restrict the language in contracts of adhesion and cut the Hydra off at the head. I'm in complete agreement with you. That is not a small project, and I'm hoping that that's the next step. That if we're successful in our antitrust law, this is where we're headed next. It's a massive undertaking, would require the usage, again, of a very well-oiled organization. So hopefully some of the squeaks that are currently in the machine that we need to iron out to actually create the current product will help us to be that much better when we take on the next project. But I'm in agreement with you. It doesn't seem exciting, right? Free speech is a much more exciting thing than talking about contract law, but that is ultimately where the solution is, I believe. It's like one of the viewers described, it's like going after Al Capone by going after his taxes, not by going after him for murder, by getting him for tax evasion. That's the kind of stuff. You go after technicalities in contract law that actually respect free speech, but otherwise change the entire balance of power that right now is completely in favor of the platform. Change the way provisions in those agreements are written so that when they invite you, when they tell you to come and build your life online, when they tell you to build your businesses online, when they tell you to create content on which they rely to make money, they would not be in a position to just terminate you because they don't like what you say or do. There have to be very strict procedures where they identify the violation, where they give you an opportunity to cure and fix it, and they cannot just terminate you. Where when there is another violation, once again, there's a chance to cure. And only if there's repeat violation and failure to cure would there be a suspension that can lead to termination, something along those lines. That's the kind of provision you would be part of a normally negotiated contract. It makes no sense that those would be completely thrown out because suddenly these platforms are in a position just to throw at you these contract of adhesion that otherwise say you have a right to give us everything, but we have the right to terminate you at any time and cause you really untold damage as a result. B. Smith. The info from WikiLeaks was about government corruption and crimes being committed, not persons or tactics. You guys would know better than me. That's why I was not responding to any specifics about whether or not there was real damage. Corruption is something that people should be telling the public, even if it's against any contract that they actually signed. So, but I don't know whether or not any harm done to any individual as a result was a direct result of information released, or was it unintended consequences of it. So it's just something I haven't followed up on. I just don't know. Derna, 1804. Aren't corporations still bound to the Tillman Act of 1907? My understanding of Citizens United was it only applied to PACs, whether they take money from individuals or corporations. I don't have enough information on it. I don't know. I don't remember Tillman Act of 1907 off the top of my head. I would have to look into it. I apologize. A sweet old man. What are your thoughts on Blackstone's formulation that it is better that 10 guilty person escape than 1 innocent person suffer? Oh my God. It leads to the implication that the law has to be beyond certain of your guilt before putting you in jail. It's impractical, but as an individual, I can appreciate it. I don't have an overwhelming position in support or opposition to it, except to say that the idea that we are presumed innocent unless proven otherwise is fundamental in the United States, and it's not something that you see in every single country around the world. And that effectively is what the implication of that is, that we are all innocent unless the government goes basically out of its way to determine that we are guilty of some crime. So I understand what's behind it, but when you read the statement in and of itself, 10-1, you would say, you know what? Given the damage that potential 10 guilty people can put, wouldn't the harm to a single individual be better than the damage from the 10 individuals? But to me, it's not, because I think that the harm to a single innocent person is probably greater than the harm done by 10 potentially, because you don't know whether or not they're actually guilty. But I appreciate the sentimentality behind it. Joe Vlogs, the way you describe the risk to other people by driving a car, I can make an argument for the dangers of holding a gun. Emotional arguments indeed. It's a thought anyway. Whew. I would argue that driving a car is dangerous. It's a necessity, but the driving a car is dangerous. Carrying a gun, I would argue, is not dangerous. Now, there might be danger in handling guns, you know, accidentals, or obviously I'm carrying a weapon and I might be emotionally unstable, or I might be getting into argument. There's a danger that I'll use it, but it's not. But a car is only used when driven. The carrying of a gun, its usage is effectively in a holster. When it's shot, it's typically in a range, or when you're lawfully defending yourself. So there is always the risk that individuals may use it unlawfully. But that's the big difference here, that the lawful usage of a car is dangerous, but the lawful usage of a gun is not, because the gun itself is not the usage, the ownership is not in itself dangerous. It's only when you are either accidentally, right? You might be accidentally doing something, or in the process of you defending yourself, which is completely legal. So I think there's a difference here. Second Fleet Actual, a reminder on guns being taken from you. No person can be held liable for being a victim of a crime. True. True. Good point. Clanseth. New York bill requiring $1 million insurance when the government wants to ban insurance for firearms. Yep. Again, I mean, let's be honest. When you want to place insurance on guns, it is not because you want to make sure that there's coverage for innocent victims. What the attempt is to restrict ownership by increasing the costs. It's like placing a tax, right? So that's why certain states place heavy taxes on gasoline, because they want you to use less of it because they find it to be polluting. That's why in Florida it's generally cheaper to buy gasoline than it is in California or New York, because we don't have as high taxes on cars. So the insurance to me just sounds to be more of another tax in order to increase the cost on guns, because it doesn't seem to be, it does not flow naturally that the usage and ownership of guns in and of itself is dangerous to me, that toward innocent people, and as a result you have to have insurance. It's definitely dangerous to people that are attacking you, but to them, I don't need insurance. Other than that, it's only dangerous in the form of an accident, right? Which obviously can happen as it happened. The question is, should you force people to buy insurance in the case of an accident? And for that, you really have to go to insurance table to see how often that happens. And my sense of it, I might be wrong, that there is not enough gun accidents happen that would essentially be made whole through insurance. Conclansith. The CDC has twice done studies that state firearms are used 80 more to defend a citizen than once to commit a crime. Interesting. Send me a link to that. I haven't read any studies on this stuff. Joe Vlogs. FTR, the restrictions on reporting individuals' name in the UK usually refers to minors in cases of sexual abuse. Okay, so you're saying, right, so beside whether or not it's legal or not, I completely agree that there should be a restriction on disclosure of minors in such cases because of the harm done to them over time. We don't have a prohibition. Mainly, I'm not prohibited from disclosing information. There's generally a prohibition when it comes to courts, so they don't release that information. So normally there's a restriction on the release of information. But I understand if the UK has it. Once again, that has no applicability in outside of its border. You cannot. It's not prohibited. I'm not prohibited from disclosing information about victims unless in certain circumstances where there's other prohibition, like in part of the judicial system, and there's actually a prohibition on it. As a citizen, I am not prohibited, and so the US will not honor a law like that in the UK in the case that I actually disclose it. So I would have to be within the borders of the UK for the UK to prosecute me. If I'm in the United States, you cannot come after me for violating what is otherwise an anti-free speech law, even one that you agree with and you find it justifiable. It's still not going to be enforceable in the US. Understeer Extra. Maybe I explained the situation badly. Please watch Drama Alert's video titled Logan Paul says bad word, Drama Alert Fortnite, and skip to 646. Okay. I will put it into the notes. Here, and I will try my best. The relevant clip is only 2 minutes tall. Okay, I'll read it. And Derf sued YouTube, and YouTube didn't want to fight the lawsuit, which is the result in being unsuspended. I'd have to see this. Let's be clear on it. YouTube is not afraid of any YouTuber, and its choice of whether or not to suspend anybody or unsuspend it has nothing to do with it. YouTube is immune, 100% immune against suspending or terminating any account for any reason whatsoever. It's not facing liability. If YouTube changed its mind, it's because it felt that it made a mistake in some way or another, but not because it's legally obligated to do so. Jar Jar Binks, thank you for the super chat. What can a judge do? If a publication ban is issued in a case and someone doxes, who can be point to if a minor committed a firearm murder? Wow. Okay. What can a judge do if there's a publication ban is issued in a case? Well, and someone doxes. The question is who, because when a judge issues that ban, it's toward the parties and the people involved in the court system themselves. And so usually when it's being released, it's usually one of the parties or their attorneys or somebody associated with them, at which point they actually can fine you, they can hold you in contempt of court because you're part of the proceeding, and arguably you can go to jail for that. But that's because they're trying to secure the integrity of the legal system here. So that's acceptable here. But the judge is not in a position to tell a private citizen not otherwise associated with the party, with the case itself, that they cannot reveal. So He has no say over that. He cannot issue a ban on speaking. So the doxing in that respect is not illegal. Doxing itself is not an illegal activity. This is a rule, a community-based rule that's been developed by the social media platform, but in itself is not illegal. The release of otherwise public information, the collating of public information, and the releasing of is not an illegal activity. I'm not sure the relation to the minor committing a firearm murder, but I hope I answered your question. Derma 1804, the Tillman Act made it illegal for corporations to directly contribute to political campaign. When we see the statistics about corporations donating, it's individual employee contribution. Companies can donate directly to political campaign. They're not prohibited from donating to political campaign. The question is what the reason why you see individuals doing it, because you can get around the prohibition. So if you say that every company can only donate $5,000, then you would say, well, I have 50 employees. How about if each one of them donates $5,000? Right? So that's how it's done. But there is no prohibition, as far as I know, and I'm pretty sure of my response here. There is no prohibition against corporation. That's really the heart of it. This is what developed. There is no prohibition about corporations actually contributing to political campaigns. Nope, help, nope. I've never had a negligent discharge. Handle firearms regularly, owning and work, but I've had 3 car wrecks. I think that is a very common sentiment. I've been in one, right? Somebody hit me in an accident, but right, because in a car, it's not just that you in your driving can cause an accident, but you might be the victim of an accident that's caused by somebody else, or simply a chain of events that causes that. That's the big difference with guns. Again, not saying that there cannot be an accident. It happens. You can watch YouTube videos. I feel terrible because I watch some of those guys on YouTube shooting themselves in the foot, and I laugh. And it's probably something bad about my personality because I find it funny sometimes to watch this stuff. But I'm in agreement. Again, the ownership itself of a gun is not dangerous. There is nothing dangerous about having a gun in your holster, of keeping it in a safe. Nothing inherently dangerous in using it, except that once you start shooting, there's a potential for an accident, right? You can argue that it cannot be, but the problem is that's so different than what cars are, where the very usage of cars at all times creates danger. That justifies insurance. Understeer Extra, the reasoning is that YouTube does not want to waste time or money on fighting the lawsuit. I disagree. They don't care about that. They'll defend it because they have zero liability in this case. Thanks for taking the time to respond. As I mentioned, please watch the video and skip. I will watch the video. Not a problem at all. We're done. So this is, it's about 2.5 hours. I wanted to thank everybody here for coming to the chat. We still have 118 people. I really, really appreciate it. If you have any concerns, any issues, anything you want to discuss, leave them down below. I'd love to talk to you. I'll see you next time.